property owner or person who is entitled to legal possession of a property can sometimes remove transient occupants from their property without the need to bring an unlawful detainer court case, but this only applies in very limited scenarios. A transient occupant is defined in Chapter 82 of Florida Statutes as a person whose residency in real property intended for residential use has occurred for a brief length of time, is not pursuant to a lease, and whose occupancy was intended to be transient in nature. There are 7 factors that establish that a person is a transient occupant and include but are not limited to: 1. The person does not have an ownership interest or financial interest in the property or a lease for the property. 2. The person does not have any property utility subscriptions. 3. The person cannot produce documentation, correspondence, or a government ID which shows that the person used the property address as an address of record within the previous 12 months. 4. The person pays minimal or no rent for his or her stay at the property. 5. The person does not have a designated space of his or her own, such as a room at the property. 6. The person has minimal, if any, personal belongings at the property. And 7. The person has an apparent permanent residence elsewhere. The owner can contact the police to file their appropriate affidavit. However, the police will make the final decision as to whether they will remove the occupant with the affidavit or whether they will require the owner to file an unlawful detainer case. Also keep in mind that a person wrongfully removed pursuant to this subsection has a cause of action for wrongful removal against the person who requested the removal and may recover injunctive relief and compensatory damages. If you would like more information about removing unlawful occupants, please contact us today.